we're back. Hi, I'm Patty Shewmaker. I'm here with my law partner, Alexa Lewis. Last video, we were talking about the Hague Convention on the civil aspects of international child abduction. And we discussed how the petitioner, the left behind parent, and how they establish a case for the return of the children. Once they've established a prima facie case, then the burden shifts to the defendant, or sometimes we refer to them as the abducting parent, to raise one of the affirmative defenses under the convention against the return of the children. Alexa, do you remember what some of those defenses are?
I vaguely remember a few, yeah. So there's several that are applicable when you're talking about within a year span of the child or children being taken from their country of habitual residence. So if the parent has consented or acquiesced,
And that's both within or even if it's been longer than a year.
Right. And yeah, but these are applicable for both. There's only one that's actually applicable when we're talking about outside of a year. And that's the well-settled defense. Essentially saying, listen, these children have been removed for over a year. They're well settled in their new country, as in they're in school, they've got friends, they've got doctors, they're established in their community. And that's, they've been gone for a while. So maybe you should have done this a little sooner. And then some of the other defenses are things like, they're a child of a mature age where at this point their opinion should matter. And
yeah, but who decides if the child's of a mature age?
That's your judge who gets to say, I think this child is a mature child and should be able to say, I want to stay here or not.
That's right, because the Hague Convention itself does not define what a mature child is.
So you could be talking about a child from 10, 16. It really doesn't matter because it's child specific and completely up to the judge. There's also, we're talking about clear and convincing evidence of physical harm to the child if they're returned.
And that's an extreme affirmative defense, meaning that it can't just be, your run-of-the-mill harm as, the schools aren't as good, in their country of habitual residence. It's got to be, they're going to face extreme psychological or physical harm if they're returned.
Right.
You've also got that it's going to be a violation of fundamental human rights if the child has returned. Do you know there has yet to be an appellate court case in the United States where a court did not return the children based on that defense?
I didn't know that.
It's such a rare defense. And you're talking about something where, you have a judge, making a judgment call on the another country and their human rights violations.
Right, exactly, which is pretty
That's a big deal.
Yeah.
Anyway, there's the multiple affirmative defenses. We're happy to talk to you more. If you have a situation like this, don't hesitate to call us, Shewmaker and Shewmaker.